You've been hit by another driver. Your car's wrecked, you're hurt, and then you find out the worst thing. They have no insurance. Now you're left thinking, who's going to pay my medical bills? What about my lost wages? What about my car? And in Georgia, if you don't know your legal rights and options, you could be left eating the cost yourself. Hi, I'm Ted Spaulding. I'm a Georgia car accident lawyer. And in this video, I'm going to walk you through exactly what happens when the other driver does not have insurance and what you can do to still recover compensation. And the point is so that you don't get stuck with a bill, blindsided by the fine print, or pressured into settling for far, far less than you deserve. Drivers in Georgia are supposed to carry insurance. We all know that. It's the law, but not everyone does, and it's quite more frequent than you think it is. And when someone is without coverage that hits you, their insurance does not have to pay a dime. That's when the panic sets in, right? No car, no income, medical bills are piling up. But this isn't a dead end. It's what I want you to understand. It's just a different path. So let's talk about that different path. That different path is a different type of insurance that exists specifically for this situation, and it's called uninsured motorist coverage, or UM. And the first thing you need to know is UM is insurance that you have, not the other driver, but you. And it's on your own policy, but it acts like the other driver's insurance. It can pay your medical bills, your lost wages, your pain and suffering. And depending on your coverage, it might even pay for the damage to your vehicle. And here's the thing. In Georgia, unless you declined it in writing, you might already have it. So let me start all of this by giving you an example. I want to talk about Lisa, a client of mine. Lisa was from Macon, and she was rear-ended in Macon. And it was a red light. She was rear-ended, and she injured her back. Her car was undrivable, and the other driver didn't have any coverage. She thought she was stuck, so she reached out to us. We looked at her own insurance, and she had $50,000 of that UM coverage I was just telling you about. So it was great news. It's double minimum. And it then helped pay for those medical bills. She recovered all of her lost income, and we got her back on the road with a new vehicle. No lawsuit ended up needing to be filed. No chasing down someone who couldn't pay and having to sue them or any of that. Having UM coverage is so important for this reason. So let's dive into more of what is UM insurance and how it works in different scenarios. So the first thing you need to know about UM coverage in Georgia is there's two different types. And here's where it gets a little technical, so stay with me. One is called add-on UM coverage. And remember, you have to select these things, so you need to know you have these options. Oftentimes, these insurance agents aren't even telling people fully about why this is so important. So you've got add-on coverage. Add-on coverage is the best one. It's the one I always recommend. It's a little more expensive than the other UM type, but comparing it, it's still pretty darn cheap. Now, the good news with add-on is it does just what it says. It adds on top of any insurance coverage that the at-fault party has. So it's there for you not only when they don't have insurance coverage at all, which is the scenario we're talking about right now, but it's even better because it will apply when they do have insurance coverage. So it is oftentimes the second source that we get for a client for their medical loss, wages, and pain and suffering. So we get compensation from the at-fault insurance when they have it and our client's UM because it's add-on coverage. So that's the first type. The second is difference in coverage UM. That means it is deducted from what the at-fault party has. So in the scenario where there's no coverage at all, it doesn't matter, right? So let's look at Lisa for a moment. Lisa had $50,000. So she had difference in coverage or add-on. It doesn't really matter because there was zero on the other side. 0 minus 50, it's still 50, right? So it doesn't get reduced down. However, in a scenario if Lisa, the other driver had 25 in coverage, then it would be reduced So she could still use it, but it's not going to be 50 on top of the 25. So it'd be another 25,000 of coverage that she would have. She would get 25 from the at fault and then 25 from her reduced by coverage for a full $50,000 settlement. Now, if she had add-on, she would have gotten 75,000 because it would be 25 from at fault and then 50,000 on top of it from her own coverage. So that's the beauty of It's not there just when they're uninsured. That's the most important reason to have it in case there's no insurance like we've been talking about, but it's also there as a supplement, adding on to what was not enough coverage from the at-fault party. So it's a really good thing to have. So if you've been hit by someone that you find out has no insurance, what's the first step? What do? Well, check your insurance policy. And quite frankly, what I tell people is just go ahead and call your insurance. They'll tell you whether you have or not. But ultimately, you want to double check that in writing. So you go to your policy and you check to see if you have what's called And typically what they'll do is they'll have a line item that says uninsured motorist coverage. And then it'll be property damage, bodily injury, and it'll have a number if you have it. And that tells you how much you have. So you're looking for uninsured, again, coverage on your policy. It's going to be below the liability section of your declaration page in your policy to tell you whether you have it, and it'll say declined if you don't, or no coverage if you don't have it. Then you want to know, is it add-on or is it difference in coverage? Sometimes it will tell you plainly there, sometimes it won't. This is where having a lawyer can really help you to figure out, is it add-on, is it difference in coverage, if you're needing to know that. Again, remember, does not matter if it's a zero coverage situation with liability. Whether it's add-on or not, doesn't matter. It's going to be whatever that number is on the deck page. So got to know which scenario you're in, but ultimately you're heading to your policy to look and see, do I have uninsured motorist coverage? Now, a question I oftentimes get is, well, what if I declined coverage? Well, if you declined coverage, it's harder, but not over yet. And not over yet for two scenarios. Number one, we would want to double check that you actually signed off on declining coverage. Remember what I said at the beginning of the video. In Georgia, you have to sign that you are refusing coverage. If they cannot produce a signature of you declining it, you automatically have it. And you have it to the limit of your liability coverage and it's add-on. Believe it or not, I have had several cases where that has been the scenario. They tell us verbally, oh yeah, they declined coverage. All right, show me the form. Can't find it, don't have it. I actually had one case years ago where we were able to stack coverages that they initially told us for the first 6 months that they didn't have for $1 million of coverage. And guess what? It was a wrongful death case. So we got the full $1 million of uninsured motorist coverage. It was an absolute great thing for our family that we were representing. So it's not necessarily over yet. We want to see it in writing. The other way it's not over yet is you can still sue the driver. Remember, you always have the legal right, no matter what coverages are out there, you can sue the driver. But the question is, do they have the assets to make it worth suing? And in my 20 plus years of doing this as a trial lawyer, I've only seen one case where they had the money. It is so easy to file bankruptcy. If they don't own property, or it's not big property or multiple properties, or have steady income, and oftentimes even if they have both, they can still file bankruptcy and avoid it. A judgment in Georgia can last years. Yes, but all it is it's worth the money it's written on, right? Because you have to go out and actually collect it. So you get a piece of paper that says you're owed this money, and it's going to sit there for 7 years in Georgia before you have to do anything else with it, saying you're owed this money by this person. But you have to go out and physically collect it from that person when they don't have insurance. And oftentimes that's not going to be worth it. It is an option, and you got to know it is, because it's a legal right you have. But oftentimes, practically, it's not a good option for you. Now, even if you don't have coverage, the other thing you need to realize is there's still some other avenues of insurance, potentially. So what are those? First, do you live with any family members who, at the time of the wreck, had coverage on a vehicle, not the vehicle you were in, but on their vehicle. This is called the resident relative situation. In Georgia, if you're living with a relative at the time of the wreck, believe it or not, their auto policy, coverage, if they have it, will protect you. Nobody realizes this until I tell them. So I'm telling you now, this is a big area where you can get additional coverage. So you've tried all other areas. You don't have at fault party had no coverage. The next question is, were you living with brothers, sisters, mothers, fathers, aunts, uncles, grandparents, sisters, brothers, again, any of these people? I've had scenarios where, one in particular here in Cumming, Georgia, where the client ends up having 6 resident relative policies, and they stacked up. This case was insane. I think ultimately with at fault, his, and then these 6 resident, it was like 8 different policies all paid out. He was severely injured, and we were able to get all of that compensation for him. So resident relative situations, coverage there can apply. And again, it then becomes the same situation, add-on, difference in coverage, those sorts of things. Next area is, do you have what's called MedPay coverage? Medical payment coverage. That is a separate line item, and it's typically not a lot of money, but at least it's something that will pay your medical bills from your policy. Now, typically, if you don't have coverage, you probably didn't pay for medical payment coverage, but double check. You would go to your policy, look to see if you have it. If you do, it could cover some of your bills or maybe even all of your bills. And obviously, don't forget health insurance. You want health insurance to pay for everything. In Georgia, it's very, very important, especially now since tort reform, that you have health insurance pay for every bill that it will legally pay. That is your ultimate stopgap to cover at least some of your bills. Now, oftentimes I get the question, well, what about a hit and run situation, which is your typical, there's no insurance, right? Because you never find out who the at-fault party is. You can't pursue them or find out if they had insurance. Well, that's simple. That becomes a straightforward uninsured motorist situation. They're considered a ghost, right? They didn't have insurance. It was a hit and run. So it automatically becomes an uninsured motorist situation. Again, now you're in territory. So everything we just went through is what you need to figure out for your hit and run case, because it's all about only your insurance. Resident relative, all of those other things apply. So it's straight from the very beginning. Now, the next thing you need to know about insurance in those sorts of situations is what happens when your insurer pushes back. Well, they're going to. So you need to know that that's going to happen, right? It's an adversarial process. Your insurance, once you have it and you file a claim, they're going to act just like the liability insurance company would have acted. They're going to fight the claim. Their job is to pay you, even though it's your insurance, to pay you as little as possible. They are not your friend. They will fight liability, meaning fault, if they can. They will fight causation of your injuries if they can. But understand, it's just like with the liability side. That doesn't mean they're right. They're doing it to try to save money. It becomes an adversarial process, just like it would have been with insurance from the at-fault party. It's no different. Again, they step into the shoes, basically, of the at-fault party and their insurer that doesn't exist, right? And they are basically trying to pay you as little as possible for your claim. So you treat it just like you would a liability insurance situation. They're not your friend. Yes, you have to do certain things because they're your insurance company that you wouldn't have to do, like recorded statements and things like that. But that's why in situations, I would always recommend you get an attorney involved, because you don't want to get taken advantage by your own insurance company. Another question that I oftentimes get with insurance is, will insurance cover the property damage? And the answer is yes. If you have coverage, it's going to be property damage and bodily injury, 2 different line items of coverage, just like with liability. You'll have the amount for the property damage and the amount for your injuries. So same scenario with the car damage. You would pursue a claim, if the other side has no insurance, and again, it's just like you're going against the liability insurer. What's the value of your vehicle? What's the cost of the repairs, rental, loss of use? All of those things apply. Again, just as if you're going against the at-fault party's insurance, it just happens to be yours, and it's your property damage coverage. So you'll be totally fine handling property damage through your insurance. Now, I want to leave you ultimately with the advice that you should speak with a lawyer anytime you have a situation, meaning, again, an at-fault party who does not have insurance specifically. I always recommend you hire a lawyer in those situations, but again, at least talk to one. Why? Because things need to happen very quickly. One big thing you must remember in situations in Georgia is you only have, case law says, about 90 days to put your insurer on notice, or you will lose the right to pursue your coverage. It's a violation of your policy. So you don't want to wait to figure all this out and call a lawyer after 90 days and then have them say, oh, yeah, did you put them on notice? Oh, no, I didn't know I was supposed to do that. Be very careful. So talk to a lawyer early on. Once you learn, and it should learn within, if not right there at the scene, within days when you get the police report that there's no insurance coverage, that's your red flag. Let me get with a lawyer. Again, whether you hire them or not is your personal decision, but get with them, get your rights figured out so you don't lose anything. So the big takeaway before you go on this video, hopefully, is that if you've been hit by an uninsured driver, don't assume you're out of options. There's often more coverage than you realize and legal leverage than you realize. And if this was helpful, this video, I hope it was. I hope you stick around. In the next video, I'll show you how to tell if a trucking company that hit you violated safety protocols. So if you have a trucking case in particular, you're going to want to watch this video. It's one of the easiest ways to strengthen this type of case and maximize your compensation. Click to watch, and I'll see you over there.